Hello, everybody. This is advocate number 6. Today is the 22nd of August, 2024. I'm Neelu Chowdhury of the Free Human Rights Advocate training videos on this video. So this website, expertinalllegalmatters.com, and if you go through that, you'll be able to work out how many billions are in your name secretly securitized. So there is another one called fidelitywalk.com walkthrough. This is part of working out how much you're worth. So this Fidelity one, you have to have a lot of hours to put into this to work this all out. I did work it out, but they don't want you to know this. So this is the trick bit, is where your numbers have spaces and zeros in places, so to stop you finding it, finding your amounts that the various companies they have set up in your name, using your account and traded you. And so he found, for example, something like 3 billion and 1.7 billion fraudulently traded there. That's the word, fraudulently trading on you. So now, taking that word, fraudulent trading, Trevor Meelam will tell you the names of the defendants that got away, but these 3 were jailed, and they said to the Criminal Appeals Court, we want our sentences reduced. So in the first paragraph, the Criminal Appeals Court, they didn't reduce the sentences, but in this first paragraph, contrary to section 458 of the Companies Act 1985, you can't prove that the banks, even the banks don't know that they're fraudulently trading our bonds, our HMRC bonds. So I'll just explain this, is that the sort code is the same for everybody, a HMRC sort code. The national insurance number, that goes into your IBAN number. So your other numbers in your IBAN number are the year when you are 15 years and 9 months old, okay? And that year, you only take 2 numbers from that year to go into your IBAN number. This guy was born March 67. So you add 15 years and 9 months to that, December 82. So it's still 82. Yeah, you get these from your national insurance number. So this is how you work out your IBAN number, right? So it's called, so you've got your sort code, validation. So here he's put the 82753307 from that number into sortcodes.co.uk to work it out. Validation, then he's worked out his IBAN number, okay? But here's 1099online.com, and you can, in America, you can fill out these forms and submit them online, but you have to be on the American, taxing code. Let's go to the Leighton judgment now. So this is the Leighton judgment. Wayne Leighton was abroad when his tenants were liable for the council tax, and the York City Council, who are not the defendant, but this is the bailiff company, Bristow and Souter, they attended 34 times, and they went to his parents' house, so they breached privacy data to do this terrorism. The judge used the excuse that the City of York Council was not a party, so that he could not say that all bulk liability orders were null and void in law. So Mr. Leighton asks, how is it if is he, as a subject of such an order, able to apply to set aside or appeal the order, right? So this is the sticky point, that the judge did not really use that precedent to all the other liability orders, 1,400. So he said that the process was flawed. So let's go to the next one for appeal. So this is now page 5 of 13. So here it says the defendants argue. Well, it shouldn't be the defendants arguing. It should be, they're saying it is a matter of law. It's not argument. So they're saying, well, he was one of 1,400. So it says, however, the way in which the orders are made certainly makes it difficult for an absent debtor. It's not even just an absent debtor, it's for anybody. Apply to set aside the appeal the same. So when you go to court and they kidnap you, like they did to Danny Beach from the magistrate's court, they've denied him his right of appeal to the Crown Court. You're allowed 2 statutory rights of appeal. So all repossessions under the Leighton judgment have been denied the right of appeal because the file was not maintained, kept in the magistrate's court for the liability orders. And on here, it also mentions not just magistrate's court, but I believe I've seen the word county court. So I can't see that now, but any court, not just magistrate's court, where any court where the file is not retained and the appeal. So when you go to, say, the county court and then you appeal it, they say make an application for a stay. That is a trap, because you need to appeal it and you need to get out of the county court to appeal it. You need to go to the High Court. So again, that's all we need from the Leighton judgment is, let's just see the word file. No, that doesn't have that. Let's use the word lab. Let's see. So the agency, the bailiff agency, contends that they were instructed to enforce 4 liability orders and acted accordingly. The claimant argues, seeking to enforce the same defendant acted unlawfully in a number of ways. So that's the breach of Article 66 of the Tribunals and Court Enforcement Act, harassment, breach of statute of Marlborough, and breach of a commercial lien. But the only thing that this will, they were denied the right of appeal. So it's more of a jurisdiction matter that the bailiffs were coming around with these. Let's see if the word High Court. Let's just go to word enforcement. Let's see how to do this all randomly. Okay, so they carry out the enforcement work for local authorities, defendants, the bailiff company. Okay, so this is against bailiffs and what they do. Okay, so let's just follow this word. Procedure for enforcement involved issuing a summons to appear before the magistrate's court. Okay. So whether they had a right of enforcement, the bailiff company. So the locksmiths is a bit, further down the line. So the authority for enforcement within area of enforcement is one of those areas that remains within the remit of the magistrate's court. Is one which is ripe for reforms, as becomes apparent, because the right of appeal was denied. So the reason cannot be an enforcement by the magistrate's court. Okay, so let's carry on. In passing the claim to the enforcement agent, the council will simply send a list of people whom liability orders have been obtained. Okay, and then they take them at the word and proceed accordingly. They have a general authority to proceed with enforcement. So anyway, That's their side of it. We're not interested in their side of it. So let's see how that 2007 Tribunals and Court. See, they get into the premises to take control of goods in connection with debts owed to City Council. Let's just carry on with the word enforcement. Okay, paragraph. So what's wrong with it? Breaches a provision of the schedule or acts under an enforcement power under a writ, warrant, liability order, or other instrument that is defective. So these instruments are defective because the right of appeal has been denied. So Nirma and her mum were in the Kingston County Court having an application for a stay on grounds that they have not had their right of appeal to the High Court, that they were at the door whilst they were making that application. The locksmith and the bailiffs were at the door, attempting to force entry and still take possession. Okay, let's carry on. Okay, so anyway, this is for you to research. I'm just skipping through the word enforcement because that's what they are doing without authority of the appeal court. Are they bypassing the appeal process? Okay. Loss suffered by the debtor as a result of the breach or of anything done under the defective instrument. There you go. That's the one that we need to get our damages sorted. Okay, that is, what is that? Remedies available to the debtor, Schedule 12, paragraph 66. So that's the one we need to go for, okay? Enforcement. Whether he's satisfied with that, whether the liability orders were made by the magistrate. So now he says that the documents, series of problems with that process. The individual orders were not readily discernible, the name of the individual making the order. So if the judge is saying he can't make out, so sometimes they just put a scribble. There has to be a name of an individual making the order. And it has to be, so he says, so they've only certified the number of liability orders that made that day and not individually dealt with the case. Okay, let's carry on. Sorry, just rushing. So the council noted the making of the same, the council then passed on the information to the defendants for enforcement. So what they've done is they cleverly removed the council so that you couldn't get them to remedy all the other thousands and millions of liability orders that they've issued over the last 30 years since the councils came in. So they're trying to defend they thought they had the authority to do this, but because the statutory right of appeal has been denied, that they were unenforceable. That's basically so that's what what is not mentioned in this judgment, where the judge has got it wrong, is anyway, you get the flow. So just curious what capacity. Okay, this one's good. Authority for enforcement action to act comes from provisions set out in paragraph 7, and it says the regulations must state the minimum notice period, the form of the notice, how it must be given, and who must give it. So this is important, is that the name has to be specified for the control of goods. The enforcement agent there must be a notice period, etc. That's important. Okay. So this is a notice. They have to make a record of the time that the notice is given. they're saying that the authority to enter premises given by the council. Anyway. And while the defendant may not hold a copy of the liability orders, they still held the relevant authority from the council to enforce their orders. See, there's a contradiction here because in the end, Wayne Layton was not required to pay his council tax because the liability order was issued by the council and not the magistrate's court. That was a big flaw that they didn't really notice, didn't use the precedent to the other liability orders, which is what we're trying to do. So the judge's conclusion was pretty biased, and that's why there is an appeal. But we're only going with the right of appeal being denied routinely because the file is not retained at the appeal court where the appeal and the statutory rights of appeal are denied. So the file never gets to the appeal jurisdiction and they come at the door before any appeals can be carried out. Right, regarding the valid order of the court, which we're questioning that is routinely not valid. So there does not identify the maker of the order, not stamped or sealed. And it purports to be the basis for an award of costs, does not comply with the obligation to make clear whether or in what sum such costs are rewarded. That in the absence of any paper record, the court should not be satisfied that any such liability order was ever made against him. So then we go on about the method by which the liability orders are produced. No record retained by the court regarding making the same. And I've covered the next point, which is that how can he appeal it? And so that the flaw in the process by which the right of appeal is denied, that's your human rights to basically agree the services that are provided to you by the public services. So the next point is that he told the council that he was not resident at the address where service was conducted, and that he says that they had pretended to serve service of the summons. So, and whether it's service of the summons or the service of the notice of eviction or notice of possession, the service has to be made. And they routinely make it at the wrong address, and they do this pretend process that they're following the law when they're dodging the process at the wrong address. Or they didn't. Even with Nirma's case, the locksmith came at the door. Nirma's mother was inside it. The mother was not served with any paperwork of their authority to force entry. And no court can order force entry unless there is a criminal conviction against that person. And they're in jail, I believe. So I think that's the main point there I wanted to cover. Okay, I'll stop now. Okay, so I've just found something else here now. The nature of the work upon which the defendants, the bailiffs, are engaged is strictly regulated. So they have to provide the name of the company they are coming from. And in order to get into their regulations. So again, back to this, it says the debtor may bring proceedings under this paragraph And so in the proceedings, the court may order the goods to be returned to the debtor. This is where Nirma's case comes in. Order the enforcement agent to pay damages in respect of loss suffered because they previously shut Nirma's shop down for 2 years. And or anything done under the defective instrument, which is the piece of paper that doesn't have a seal, stamp, signature, or a name of the person at the authority, and whoever is whatever instrument that they've used that's defective, because the right of appeal has been denied. You cannot enforce an instrument unless all the rights of appeal have been exhausted up to the appeal court. So they're doing all this through the county court. They're doing shortcuts. So this is the remedy section of the Schedule 12 of that one, paragraph 66. Okay. If you want to find that, we go to, one second. So here is the Tribunals, Courts and Enforcement Act 2007, Schedule 12. So this is where you see that section, paragraph 66, paragraph 4. So the High Court is called a writ. It's called a writ of the High Court, or the County Court's enforcement powers is called a warrant. But the right of appeal must have been exhausted, the 2 rights of appeal. And this is paragraph 5 that we saw. Anyway, that's where you find the whole law, to quote. You just noticed here, paragraph 6, it says a related party is either, if different from the enforcement agent, so that the locksmith is the person on whom the enforcement power is conferred, they have to be named on the warrant from the county court or writ of the High Court, or it has to be the bank or the council if it's a council tax. Has to be somebody from the council. Okay. So we've got precedents now that they can't say they didn't know the law, that they were acting in good faith, and they can't get away with it anymore because there's enough publicity about with the Leighton judgment anyway. Okay.